Good afternoon, constitutional law students. This is a brief lecture in which I will discuss some of the general themes relating to the right to privacy. Specifically, my lecture will cover what is the right to privacy and how have unenumerated privacy rights attained or lost the protection of the U.S. Constitution. Recall that both the original Constitution and the Bill of Rights list specific limitations on the power of the national government. Those limitations explicitly identify several civil liberties that the founders considered significant at that time. We call them enumerated civil liberties because they were listed specifically in the Constitution. But the founders did not intend the explicitly identified liberties to be the only liberties worthy of protection. We see direct evidence of that fact in the Ninth Amendment, which reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." So what are those others? The liberties deserving protection which were not explicitly identified. Naming those others requires a process, and we call that process substantive due process. Substantive due process tells the government what it shall not do. It should not unjustly interfere with liberty. So the answer to the question, what is the right to privacy, is centered on how the U.S. Supreme Court has defined liberty. As we learned in prior modules, liberty was, for the first time, extended beyond just freedom from physical restraint in the early 1900s with the case of Lochner versus New York. The Supreme Court found that liberty includes a freedom to contract. In later years, it came to mean more than just economic choices, but personal choices as well. In order to define the choices that are encompassed in liberty, the courts often asked, what freedom is so rooted in the traditions and conscience of our people as to be ranked as fundamental? In this way, the courts have defined liberty in its historical sense, the way people might have defined it when the 14th Amendment was originally written. In several Supreme Court decisions, going back a century or more, the existence of a general right to privacy was acknowledged. Various justices noted that, historically, liberty included the simple right to be let alone. It was an underlying assumption throughout U.S. history. Yet in 1965, the Supreme Court gave a more intentional description of the right to privacy for the very first time. In the case of Griswold versus Connecticut, the court officially held that liberty includes a right of marital privacy. Writing for the majority, Justice Douglas stated that liberty includes unenumerated rights that are peripheral to enumerated rights. He described them as being within a zone of privacy created by the enumerated liberties that protect people's privacy in their home, such as the Third and Fourth Amendments, and that protect a person's freedom from physical restraint, such as the Fourth Amendment. Justice Douglas's analysis was somewhat distinct from the way the court regularly defines an unenumerated liberty. But the Griswold decision supports the general principle that a right to privacy is part of liberty, and so should be considered fundamental to freedom. When the court determines that a privacy right is fundamental, it will apply strict scrutiny to any law that restricts it. The government must show that its law is advancing a compelling government purpose, and that its law is necessary and narrowly tailored to the advancement of that interest. In Meyer versus Nebraska, 1923, the Supreme Court had an occasion to consider whether an unenumerated right was protected by the Constitution, an unenumerated personal right. And in that decision, the Supreme Court listed several rights considered fundamental, but which were not specifically listed. They included the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home, and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law. None of those specific liberties were at issue in the Meyer case, but the list has been quoted many times. As you see, as you will see, the right to marry is among those rights so rooted in our history as to be considered fundamental. The right to marry is without question a fundamental right. The cases involving the right to marry never challenge that central conclusion. Instead, whether the right to marry Instead, they determine whether the right to marry is affected in any way by who is asserting the right. Does a white person have a right to marry a black person? In Loving versus Virginia, the Supreme Court said yes, he does. States cannot prevent individuals from exercising their right to marry based upon their race. Denying the right on the basis of race is a violation of both the due process right to marry as well as the Equal Protection Clause. Does a man have the right to marry another man? Or does a woman have a right to marry another woman? In Obergefell versus Hodges, the Supreme Court said yes. The right to marry, as with any individual liberty, cannot be circumscribed by the gender of the person seeking to exercise it. The Supreme Court in the Obergefell decision described the issue this way. If rights were defined by who exercised them in the past, then received practices could serve as their own continued justification, and new groups could not invoke rights once denied. So the right to marry then has been described as a right held by individuals without regard to their race or their gender. The right to privacy has most often been associated with the right to an abortion, recognized by the Roe versus Wade decision. But the right to privacy did not begin with abortion. I hope you see that now. It has a long history. And Roe versus Wade was just the culmination of a line of cases specifically directed at the individual's right to make private, intimate choices involving procreation and reproduction. And so I'm going to go over that now. In a very shameful time of world history, policymakers adhered to a philosophy known as eugenics. That was a belief that government could manipulate the characteristics of the human race by limiting undesirable genetic traits through a variety of mechanisms, including forced sterilization. And sadly, the Supreme Court upheld a law that allowed a state to forcibly sterilize mentally disabled people. But that case was an aberration because subsequent decisions recognized instead that the right to procreation, the right to have children, is a fundamental liberty. The Griswold decision upheld the privacy right of married couples to obtain contraception to set their own timetable for procreation. Building upon Griswold was Eisenstadt versus Baird, which extends the right to contraception to unmarried individuals. It is that we have an individual right to contraception, and that was extended further to minors. In Carey versus Population Services, the Supreme Court framed the issue as the fundamental right to decide whether to bear or beget a child. This is where Roe versus Wade fits in. The right to choose to terminate a pregnancy, to not bear and beget a child, was the issue in Roe versus Wade. So it falls into this sequence of many different cases addressing the individual right of reproductive freedom. Roe versus Wade was criticized as ignoring two critical issues. The first criticism related to the long history in America of laws that restricted a woman's ability to terminate her pregnancy. The majority in Roe did acknowledge that history, but it concluded that those laws were enacted during a time when abortions were far more dangerous and when women were considered second-class citizens, not worthy of the same liberties as men, not even the liberty to vote. And on those grounds, the majority in Roe chose not to allow historical traditions to define the limits of liberty. The second criticism related to the existence of at least the potential for life growing within the woman. This criticism is often grounded in religious and moral principles that define life as beginning at the moment of conception. And following that reasoning, the additional fetal life deserves the same protection as the woman's liberty. Roe acknowledged the state's interest in protecting fetal life, noting that states have varying theories for defining when life begins. It also acknowledges states' interest in protecting maternal health, but the majority considered these interests to be progressive interests that grew more compelling as the pregnancy progressed through the 3 trimesters. And that is why the Roe Court developed the trimester test for abortion restrictions. Those two criticisms of Roe influenced the Supreme Court in the early 1990s. After about 20 years, the Supreme Court ruled in Planned Parenthood versus Casey that Roe's trimester framework was an inappropriate rubric for testing laws that restricted abortion. The Casey decision upheld the central holding of Roe, that the Constitution protects the privacy right of a woman to choose an abortion, but it invalidated the rest of Roe and established a new test, the undue burden test, which provides an undue burden exists, and therefore a provision of law is invalid if the purpose or effect is to place substantial obstacles in the path of a woman seeking an abortion before the fetus attains viability. That undue burden test governed abortion cases for another 30 years, until politicians succeeded in seating Supreme Court justices who were willing to overrule Roe v. Wade entirely. And that brings us to the most recent abortion decision of the U.S. Supreme Court. Dobbs v. Jackson Women's Health in 2022 struck down Roe's central holding, as well as Casey's undue burden test. Now, state restrictions on a woman's right to choose an abortion must simply satisfy the rational basis test. It is helpful and important to consider the distinctions in the various opinions written by the justices. It seemed that each of them had something to say about the issue. First, we go with the majority. The majority together agreed that Roe was wrongly decided on the basis of those two criticisms I explained a moment ago. But other privacy rights, including the right to marry, are still sound in legal theory. So they held that there is no fundamental right to an abortion within the scope of the 14th Amendment. The meaning and protection of liberty, then, is limited to its historical context and in the history and tradition of the nation at the time of the ratification of that amendment. At that time, every state made abortion a crime. The majority held that Roe misconstrued or wrongly ignored those laws. The other precedents defining liberty, those upholding, for example, the right to marry, are not upset by the Dobbs decision because they are sound in the proper interpretation of law in light of history and tradition. Justice Kavanaugh wrote separately to emphasize that point, to emphasize that overruling Roe v. Wade should not affect protection for other privacy rights. Justice Thomas, writing separately, disagrees with all use of substantive due process and contends that due process is a matter of procedure only. So he would overturn all applications of it going all the way back to the late 1800s. Chief Justice John Roberts agreed only with the outcome in the Dobbs decision. He did not believe that the central holding of Roe and Casey needed to be overturned because both precedents boiled down to the protection of a woman's choice. The particular law at issue allowed abortion before 15 weeks gestation, which gave women sufficient opportunity to discover the pregnancy and choose what to do about it. The dissenting justices believed that the majority is ignoring a key fact. Women were not allowed to vote when the 14th Amendment was ratified, so of course abortion prohibitions were commonplace at that time. For that reason, liberty cannot be fairly limited to its historical context. The historical context was unjustly biased. So the dissent pointed out that the original founders of our nation recognized and intended that their words in the Constitution should be interpreted in light of modern understandings so that the words could last for the life of the nation. When the court decides that an asserted privacy right is not protected by the Constitution, such as it did with abortion, the right then becomes subject to political processes, where political majority groups are able to supersede the interests of political minority groups. The laws will vary state to state, depending upon which political group holds the majority. Some states offer a great deal of protection for a woman's right to choose an abortion. Other states offer little, if any, protection for that right. Hopefully, though, you can see now the larger question that exists in the constitutional decisions involving the right to privacy. It is a question of how the courts ought to define liberty. Should the definition be limited to its historical sense, or should the liberty be permitted to evolve and be shaped by new ideas and understandings of what it means to be free? There are other right to privacy issues and cases in your textbook that you should read that I've not covered in this lecture. I simply wanted to give you the broader themes and context for the chapter as a whole, and now you can go and see how the other cases fit into those two themes. If you have any questions about what you've read or heard in this lecture, feel free to give me a call or send me an email. And of course, if you're on campus, feel free to stop by and say hello.